Good morning, and thank you all for joining us today on the webinar, talking to older clients about estate planning. My name is Diana French, and I'm a product manager here at Octopus for the inheritance tax business line. I'm joined today by Tish Hanifan, who I'm sure many of you will know. She's the founder and joint chair of the Society of Later Life Advisors, also known as SOLLA. Tish is a barrister and has got extensive experience in areas of legal training and policy development, and also in relation to advice of older clients. So Tish is an excellent person today to talk to us about working with older clients and to talk to them about estate planning. I'm also joined by my colleague Nick Bird. Nick Bird is a senior business development manager here at Octopus, looking after the London region. Nick has worked for Octopus for more than 5 years and has significant experience in financial services, having worked in the sector for more than 15 years. Nick is also an affiliate of STEP. So today, both Nick and Tish will be talking to us about advising older clients with regards to their estate planning. It's a hot topic at the moment and has been for a number of years, and it's an area where individuals really turn to financial advisors to help guide them. The mill rate band is frozen until 2021, and with the introduction of the residence mill rate band last year, along with increasing property prices, it makes it an area of advice that people really value and that they really need as well. In autumn last year, here at Octopus, we launched a campaign which aims to help people grow their IHT business. So this webinar actually coincides with a guide that we published earlier this month, which is called A Practical Guide to Advising Older Clients About Estate Planning. And we hope that the webinar today, in conjunction with the guide, will really help you with this area of your business. Now, before we begin, just a couple of housekeeping things to run to. On the right-hand side of your screen, there is a bar. Now, if through the webinar today you have any questions, please type your questions in the box. We will do our best to answer as many questions as we can at the end. There's over 500 people registered for this webinar today. So, as I said, we'll do our best to answer as many questions as we can at the end of the webinar. But for any that we don't get round to, we will probably look to put something out towards the end of next week, just answering a lot of those questions. So please do make sure that you ask your questions. Also, if you have any technical difficulties, so if you can't hear us or you can't see your screen, just let us know. Otherwise, we're just going to carry on talking with no one able to hear us. And yeah, if you would like to talk about any of the points further that you find in this webinar today, please let us know and we will arrange for your local business development man to call you, or business development manager, sorry, not man, there's women as well. So the first thing we're going to do is ask a couple of poll questions. So after the question is asked, you will see a box that will pop up on your screen, and please tick the box that is most relevant to you. So the first question that we have, on a scale of 1 to 5, with 1 being low and 5 being high, how important do you think growing the estate planning side of your business will be in 2018? So the box will have now popped up on your screen. Just a reminder, 1 is low and 5 is high. Great, okay, thank you. And the second question of today, have you written business property relief business before? Fantastic. Thank you to all those that have answered those questions. I'm now going to pass you over to Nick.
Thank you, Diana, and good morning, everyone. As ever, we have to start with the risk slide, and it's always important that we do. I won't read through the entire risk slide here. I think the main important part is this is designed for professional advisors only, so not to be relied on for retail investors. Clearly, any investments we talk about can go down as well as up. And indeed, the tax treatment that we're talking about today can be available for significant change in the future. In terms of the agenda, let's say Diana says we've got plenty to get through. Tish will be doing the main amount of the speaking today, and she'll be going through a number of different scenarios about working best with vulnerable clients, how we work through that. I'll be coming in at the end, talking more practically about business property relief and how we look at to help you there. In terms of Octopus, hopefully you all know us. We've grown to be a significant company and very much a market leader in all the planning areas that we work in. I guess of particular relevance today is the business property release side. We now run over 2.6 billion of assets in that area, so we're a huge player in this. It's a big number, but we're more proud to say that we've helped thousands of clients and indeed thousands of advisors meet their planning goals. And that really is, when you work with Octopus, that's really at the heart of what we do. So I hope you find this session useful. I'm now going to pass across to Tish, who will tell you about SOLLA and how they can help too.
Yes, good morning, everybody. First of all, I'd like, by way of apology, for those of you that think you're getting bad reception, it's actually that I've really got the end part of a cold. There's only one thing worse than delivering a webinar when you're in this position, and that's for those of you that are listening, so I apologise in advance. I know some of you will either be SOLLA members or they'll be familiar with SOLLA, but I would just like to say a little bit about our background. As you can see, it says we help advisors develop skills for advising clients in later life. The reason why we set up SOLLA is really simple. There are some brilliant financial advisors out there, and there are an awful lot of people that really need help in this increasingly complex area of advice. And so in many ways, what SOLLA does is simply that. It links advisors who've achieved our specialist credit accreditation, which is an objective way of determining above regulatory competence, and it links those with the people that need them at the right time. Now, along with that, if we are going to have an organisation that evolves with the times as well, and with the increasing need for older people, the help they need, we obviously then have to produce as much as we can of technical support and training. So SOLLA members of SOLLA will get ongoing training, and people that are looking to achieve the accreditation will get ongoing training and support to help them to get to that standard. Now, we are lucky to have people, strategic partners that work with us, and one of those is Octopus. So this sort of seminar today and a webinar is a really good way for us to just add something around this whole part of talking to later life clients. When we're talking to later life clients, one of the things that's really important though is to looking at the soft skills. So I'm going to do two things really in the session I'm doing with you today. One, I'm going to look more at the bit about what it means to be an older person interacting with financial advisors and needing financial advice. And along with that, I'm just going to, at the second part, I'm going to look a bit more at powers of attorney as well, because as you all know, there is a lot of older people who don't engage directly, they engage through third parties. So when you're dealing with older people and the later life clients, you may be dealing with them directly. And I'd like to just talk through, as the guide does, some of the soft skills and the things that are specific that you might need as an advisor around dealing with older clients. And when I say dealing with them, what I mean is the objective of this really is to look at how you can optimize the financial benefit that older people get by making their experience of relating to the advice they get better. So I'm going to look at that, and then just a little bit around what if, however, you're not dealing with a person directly, you're dealing with their attorney or someone that has what we call substituted decision making. And I say that because we tend to say powers of attorney, but of course there are other ways in which people make decisions for older people. When the Financial Conduct Authority have been looking at the area of the ageing population, which I'll turn to in a minute, one of the things they identified was, for example, that there is very low understanding amongst the older person population of powers of attorney generally, but also of wider things like third-party mandates. So I'm using the term substituted decision making when I'm really meaning any way in which someone else has a lawful reason and a ground to be making decisions on behalf of other people. So what I really would like to do is just to look a little bit at the soft skills that are involved with that. There's a huge amount. As I said in the introduction, this is a really, and I say the word hot topic. This is something that the financial services sector in all areas have looked at in detail, certainly in 2006, 2017. So there were four papers that I would say that if you're interested in this area and you're keen to develop your skills in this, there are four really useful papers that you could do some additional reading on. Now, what I'm going to do today is highlight some of the parts from them, But at the end of this webinar, when Octopus and SOLLA are contacting those that logged in, we will make these links and things available to you. There's a reference to one of them, in fact, in the guide itself. So you're probably all aware that one of the focus areas for the Financial Conduct Authority in 2006 has been that they have run an ageing population project. And that's had some papers that have evolved from that. So ahead of running the project, they actually wrote an occasional paper on vulnerable customers, which was published in February 2015. And then they ran the Ageing Population Project in 2016. That culminated in last year, at the end, in the autumn, they produced occasional paper 31. And as I say, we are going to give you a link, please. So there's no need to write them all down as you do them. But it's actually called Ageing Population and Financial Services. And it has some really key insights into what makes it different and in what ways you may need to look at your advisor practice when you're dealing with later life clients. They then rolled this into a wider publication they produced, which is the FCA's Our Future Approach to Consumers, which came out later last year, November 2017. Just to say as well that interestingly, in the 2015 one, although it was described as vulnerable consumers, didn't actually really define vulnerable specifically. That has been defined in the new Future Approach to Consumers, November 2017. And the definition is described by the FCA as people who can readily be identified as significantly less able to engage with the market, and or people who would suffer disproportionately if things go wrong. So if you were to look at that definition of vulnerability, it's very wide. It covers a lot of different people in a lot of different situations. So I'm only going to focus on the aspects of vulnerability in relation to later life today. But obviously the topic vulnerability has a much wider impact, but we're going to look at it simply in relation to older people. And I think there's one thing you can all see there. People who would suffer disproportionately if things go wrong would have two areas of reference, and one of them is for older people. Obviously, the older you are, the less likely you are to be able to put mistakes right. And also, as you see on the slide here, later life clients require a different approach. Actually, some people may arrive in their later years and they may be asset rich, but they could be, as it says here, cash poor. And so the opportunity to access some of their assets at short notice is not something necessarily that's available to them. So one of the things I think we've all sort of, when we've discussed this, thought we wanted to say to you is it's really important not to pigeonhole people. One, all older people have in common really is that they're of a certain age group and therefore have a certain perhaps background of life, the things that they knew when they grew up. But just like with every other age group, there's a huge array of different people in different circumstances. So, you know, you need to be conscious when you're doing that, not to start to pigeonhole people. So they may be asset rich, they may have concerns about whether they can afford later life care, should they need it. I'm going to look at dementia and other mental health issues. And the ongoing thing, which is really important in financial services and later life, I know some of you are very aware of this, which is the way at which and how much they can have what we call multi-generational advice. So how much they want to involve their family, how much we can have their families wishing to be involved. And balancing those different objectives, that if they do need later life, if they need care in later life, they may also wish to leave a legacy. The last sort of point there says they have difficulty in making certain decisions or be vulnerable in other ways. I will pick this up as we go through this, but it's quite important, I think, to remember that we can easily fall into the mistake of thinking that older people may have dementia, they may lack capacity in some way. And we do focus quite a lot on how we will deal with those clients. And I know there's a lot of work, certainly SOLLA does it, around mental capacity, around working with other people. But I would today like to highlight the other issue, which I think is a fascinating issue, and one that the FCA, I have to say, have produced some really good information on. When they did their Ageing Population Project, they also looked at a report they've done called The Ageing Mind. And as I say, we'll give you a link to that. But the aging mind is really focusing on something which I think in financial services and giving advice is really important, which is that even if you don't lack capacity or have a neurological reason why you're no longer able to make decisions for yourself, or why you can but you find it hard, just simply aging has an impact on the brain. And the people who are healthy and have what we would call a healthy brain will still have changes in the way in which they can access information, their emotional response to information, and their over-reliance perhaps on strategies they already have. So one of the things I just wanted to pick up really today as we go through this is dealing with clients who do have capacity, but for whom we may need to treat them differently, just because they don't have any problems with this, but they are, their aging brain, albeit a healthy brain, means that they would find it easier if you worked with them and recognised how that might need to change some of the ways that you deal with them. So this next slide is actually something that's highlighted as well in the guide. It's all around the actual arranging meetings with people. And there again, going back to this, when you look at some of the research material I've referred to does make a lot of observations about this, that people with experienced cognitive decline in different ways. So arranging meetings, remember the capacity to make decisions is not always clear cut. Now there's two elements to it. One, in terms of the mental capacity, if you're working with a power of attorney, remember that the power of attorney always has to decide whether or not this is a decision the person can make for themselves, and if they can, they should make that decision. If the person can't make the decision for themselves, attorneys are required as well to see whether or not they can participate in that decision. So they might not make the whole decision, but they might make some of the decision or have some involvement in it. Now, if you're doing issues such as people going into nursing care with dementia, for example, the chances are that the attorney's already gone through that process and the person isn't able to make those decisions. But for people who, dementia is not a one or the other situation, it's a period of decline. It may be that they can help and make some involvement in some ways. It's very important to involve them where they can. So if you're talking to an attorney, I think it's good practice to just to reference and to note that you have that discussion with them about how much they're going to make that decision, and they've arrived at the decision why Mrs. Smith can't make that decision for herself, and note that to make it clear that you understand why you are dealing with this attorney and not with the person themselves. Now, the time of day and surroundings, we do a lot of this in the Society of Later Life Advisors. These sort of things are really important. It's key to whether or not you get the best outcome for a person. So, for example, some people, depending on what medication they're on, may just be better at some times of the day than the others. And you should always, if you're working with someone, tactfully as you work with them, see if there's better times of the day for them. A good example of that is Parkinson's disease, where people taking their medication at certain times may have considerably improved cognitive function in that sort of window after they've taken it. Surroundings, that's true too. I mean, today's a really short session, so I can't go through all the physical things that you should do to make your environment in which you have the meetings important. But I would say, as a practical thing, why don't you stress test it by walking through how that would happen for an older client yourself, or perhaps getting a family member who's older to come and look at that for you and see if it's actually as beneficial as you think it is. There's a couple of things here about more than one session visual aids. I just want to pick those up. One of the things that's come out of the research on the aging brain is that the fluid abilities of older people are not as good as they age, even with a healthy brain. And by that, what that means is, in order to absorb complex information, as people get older, complex information is harder for them to absorb. Making it easier for them by having more than one session would be really helpful. Visual aids is literally about, looking at, some people don't lack mental capacity, they have physical disabilities which impact upon their ability to absorb information. Look at the aids that you give. If you have a computer there, can you raise the font, etc. Now, they're practical points, but they can make a whole big difference to the journey that person has. Meeting alone, I'm going to pick this up again later on under powers of attorney. Quite a controversial subject, this I know, so I'm just going to express a view that I have. Whilst it's really important that the older person, if they have someone they trust and they want to bring along with them, that's absolutely fine. But I would really ask you to test that discreetly but firmly. So in other words, is this person coming along with Mrs. Smith because Mrs. Smith needs some support and help? Or are they coming along with Mrs. Smith because they want to guide her thinking and influence her outcomes? If you think the latter, and there's things we'll mention later on about what you do if you're worried about safeguarding, then it is really important to make sure that at some point you see this person on their own. In Solicitors for the Elderly, for which I have a big involvement, we actually produce a leaflet called Why Am I Standing in the Waiting Room? And it's a leaflet given to solicitors that can help them to explain tactfully to someone why it's really important, and you can turn it into a positive thing. You can say to this person, look, you know, I know you mean well for your mother, but if at some point someone, one of your siblings or someone else was to query this meeting, if you had been in the room, albeit we both know that you're only there to help your mum, that could look as though you was undue influence. So you don't have to do it in an accusing kind of way. You can turn it into a collaborative point. And actually, that's really true. You know, that people could be meaning well, but it could be that it could have the wrong influence to it. And these things are always fine until someone challenges it. So look to see and document it. Over and over again today, we're going to say the same thing. You need to document things. Support. This is really important too. Some of you, I know in SOLLA, we ask our members to tell us about their practice they have for how their care policies and how they work with older people. They have their own policies for that. One of the things that if you don't have one, you should look to have one. And if you do have one, you should look at it every so often to see if it's up to date, is to look at how do you actually support people at that meeting and after that meeting. So do you bring them, do you have any sheets and things that help them to take notes at the time? Do you facilitate that? Really look at how you write to them afterwards. I'm obviously know that you have to write all the FCA requirements, so that goes without saying, but there isn't any reason why you can't also write some really clear, simple things that arose from that. And what I would say over and over again, all the research through this Aging Population Project shows is that it should be bite-sized chunks, making it easier. So there again, when you look at this slide, understanding potentially vulnerable clients, do you have an older and vulnerable clients policy? And by that, that means, do you look at the way in which your process might help a person who is older, and we're going to talk about older today as vulnerable. And also the other side of the coin, is anything that you do actually a barrier to them being able to access that information? So for example, if any leaflet you've got is a really small font size, that might be a barrier to them looking at it. If the only information you've got is, I would say, deep in and covered by the FCA's guidance on what you need to tell them and that's it, would that be enough? Would they understand that? Now, so look at your policies to see how you make that. What happens when people call? What do you say about, what's your policy around having an older person have someone with them? I'm not going to go into that today in great detail, but I am still surprised by the number of well-meaning organisations that insist that Mrs. Smith has someone with her if she is a certain age. So they will say, well, you know, we have a view that if we have clients over 80, we would never see them on their own. That might be well-meaning and the subject for a longer discussion on another occasion, but I would say, ask yourself, could you justify that? What about if Mrs. Smith really wants to be seen on her own? Who are you protecting there? Are you protecting Mrs. Smith, or maybe are you protecting yourself, in which case I would say, are you putting the consumer first? So keep an open mind. We've put this in because on the earlier slide, we were talking about different categories of people and not pigeonhole them. Well, people can be vulnerable even if they were financially successful. And by that, what I mean is, supposing you've had a client, you've had them for years, you're very used to dealing with them, you know them well. As I said earlier, even a healthy, and they don't lack capacity as such, even a healthy brain ages differently. And actually, if they were financially successful, then the part of them that looks at the bit that changes as you get older is the fluid intelligence of bringing in new things, of adapting, of being adaptive, and being able to take in the amount of information you did. Now, for most people, as they age, even a healthy brain will adopt coping strategies. And coping strategies often reach back to that time when they were able to do things. So sometimes people who are financially successful might find it hard to look at new situations and will be reaching back to what they did when they were able to do things. And one of the things that the research on behaviour of older people clearly shows is that one of the situations where it's very hard for an older person, or harder as time goes by for an older person to use that fluid intelligence, is in complex situations and in new situations, things they haven't dealt with before. Now, I say that because one of the areas where people perhaps haven't dealt with before might be things around care funding. It may, very often you all know, it's not something people have dealt with before. That's what they always say to you. Such a complex matter, and I've never dealt with it before. And so this is a classic example of people could easily appear to be very, very financially competent and able to make decisions, but they actually will find new financial decisions that they haven't made before more difficult. The complexity of it will not be as it was, and they may easily default to the way they thought and dealt with things before, which may not translate helpfully into, for example, making changes. One of the things that behavioural economics teaches us about older people and the coping strategy, and you probably all see this in practice, is that they have a disproportionate regard for brand loyalty. Now, that may be a good thing, but it may also mean that they need to be given clearly, steadily complex decisions that help them to open their eyes to different opportunities. So don't think just because someone was financially successful that they are actually necessarily able to make these decisions. And we put SOLLA training there because that's one of the things. When we set up the Society of Later Life Advisors, we went to people like as age concern, as it was at the time, help the aged and which, and said to them, we're going to set this organisation up. I know that sometimes there is a negative views around financial services, particularly with vulnerable older people. What do you think a good financial advisor would look like? And one of the things that came back over and over again was, it isn't just what they know, it's their ability to use that effectively with older people, to have some understanding of the differences that it is that when you're dealing with older people, and soft skills. So today a lot of it is about that, and it's one of the areas because of that that SOLLA does a lot of training with. And it's why we're grateful to people such as Octopus that have helped us. And with this guide, for example, haven't just given you information about estate planning, but have actually put that in the context of the soft skills you need to get that right. So when you say documenting meetings with older clients, this is really important. Full and comprehensive notes about what was discussed. This is something the legal profession are very used to in relation to older people, how key it is with things like wills. You can just imagine wills are made and people think they've done them, and then later someone challenges it. The real key point that determines whether it is valid or not will be the notes that were made at the time. So full and comprehensive notes about what was discussed. And again, making a list of everyone who attended and their relationship to the client. So that would be who was there. Was it a neighbour? Were they there to support them? Was it a relative? If it was a relative, you do need to have noted, do they have other relatives? How does that translate into, for example, if they've got a power of attorney? Was it one attorney there? And we'll mention this later. Were there others? Are some of them attorneys and not others? It's not that you have to make a judgment about that. It's that you have to show that you're aware of that, because that may have an impact later. If someone were to say, I've got no idea why my mother came and brought X, Y, Z with her, and I'm surprised that you didn't query that. So you're not making a value judgment, but you are recognising that there may be circumstances where that meeting may be called into question. And as I said before, consider meeting the client one-to-one. This may not be for a whole meeting, it may just be for a part of it. But what you have to be able to do in your full and comprehensive notes is to be able to have something there that documents that you felt that the person was happy to have someone else with them, why they've chosen to do that, who that person is, what the relationship is, and indeed that you did see them on their own to ascertain that information. That's where it comes about identifying any potential conflicts of interest. You're only identifying them. There again, you're not making a value judgment on them. It's, you know, the press is full of examples of families that exploit their elderly relatives. It makes good journalism, and it really is true. But in the real world, the world is also full of lots of people who aren't doing that, who genuinely are acting in a person's best interest. But you do have to have that bit that says to identify any potential conflicts of interest. You'll see that I'll give you two examples. One would be if, for example, you're looking at an immediate needs annuity. Now, I am not a financial advisor, I don't intend to talk about the merits of these, but what I would say is it does require a lump sum to come out of the estate, of the person's money, ultimately their estate. Now, if that person is also a beneficiary, although it might not be the way you would evaluate that risk, they may be thinking, I don't want to spend that large amount of money. And that may not necessarily be about securing the right home for their mother or securing a long-term plan for their mother. It might just simply be that they see that as a big a large amount of money that potentially could have been theirs. You can't know that, but you have to identify if they are hesitant about that, what their reason is why they won't do it. The other one, of course, as ever, is equity release, with exactly the same thing. There are lots of circumstances where the press pick up that Mrs. Smith took her equity release and her children didn't know, for example, till she died, and then they found that there was a charge on the home. Actually, Mrs. Smith is perfectly entitled if she wishes to do so. You know, this is her decision. But if she has family relatives with her at that meeting, they may have the same view as about a large amount of money going in terms of their inheritance. Most people don't, but some do. So you just have to actually be aware that there might be a potential conflict of interest and notice that. So documenting it is really key. I want to pass on to the bigger topic of making decisions on behalf of others. Now, we've put one slide in on this. We could put hundreds in on this, I'm sure. And actually, each one of these points on here, making decisions on behalf of others, could warrant a whole session on itself. But I'm just going to run through the key points. So just to go back, so I'll just flick back to that. Why put, as with a will, clients should be encouraged to think about a lasting power of attorney. Why put a lasting power of attorney in place? I'm highlighting this because, yet again, when the FCA looked at the Ageing Population Project, one of the things they identified where financial services could help would be in raising the profile of lasting powers of attorney. So it's actually one of the things that the FCA said in terms of what you should do if you're a later life advisor, if you're working in this area, advising older people. One of the things you should be aware of is the benefits of an LPA and being able to explain that to a client, how that would work. As I said, along with that, perhaps not even just raising the profile of other ways that you could do it. For example, as I said, one of the things that was most misunderstood was a third-party mandate. Now, in fact, a third-party mandate for someone is often a very good idea for people who want others to do things for them. They possibly do have the capacity to do it themselves, but they physically don't. Not everybody who uses a power of attorney uses it because they haven't got capacity. A lot of people use a lasting power of attorney or any kind of attorney or substituted decision making simply because they are not physically able to, they perhaps don't see as well, hear as well, don't walk as well, and they may just want someone to do that for them. Now, third-party mandates for things like banks would be enormously helpful. One of the things the FCA found in their research was there was a very low understanding of actually the fact that you could even have a third-party mandate. So talking about putting an LPA in place, encouraging people to do LPAs. The FCA, in their strategy, in their report, we're very much in favour of the new digitalised powers of attorney that the OPG are encouraging. That is not a subject I'm going to get on, but what they are very certain about is why are they so keen on that? Because of the fact that if someone doesn't have a power of attorney in place, then it may well be that if they have to make a decision in a hurry, for example, someone may have a catastrophic situation arise where they have a stroke or something, and immediately they're going to look at needing care. If they haven't thought about putting a lasting power of attorney in place, yes, of course you can apply for a deputyship order, but these things all take time. There are relative arguments about whether a deputyship order is better than the lasting power of attorney. That again is not a subject I will go through today. I would just say that there's been quite a lot of discussion in the press where a very senior judge who retired went on to say that he felt in his view that deputyship orders were preferable to lasting powers of attorney. And I'm not going to make a comment on whether that's right or not. What I would say is the great outcome of that was that everybody started talking about the relative merits of LPAs and deputyships. But one way or the other, you know, the point is if you've got an LPA in place, you certainly know that you are choosing the person who will make those decisions for you, and they are already in place. I thought it might be useful just to give you some of the figures that are currently out on the number of lasting powers of attorneys. So I'm just going to, just before the end, I will bring forward to you the numbers of lasting powers of attorneys that have just been produced. But what I would say is the trend for lasting powers of attorneys is up. So there's been more lasting powers of attorneys registered from July to September from the OPG. I know that enduring powers of attorney, the numbers registered are falling. You would expect that as time goes by. I seem to remember that they fell by 11%. So there is an increase in lasting powers of attorney. It's really important with your clients that you feel confident that you can talk about what a lasting power of attorney is, what it would benefit, why they should have one. Because if they don't have one, that is a key point and will prevent sometimes decisions being made at the right time. Now remember, you're advising the donor, not the attorney. This is an ongoing issue for financial services. The donor is not the person, is not your client, it's the attorney who is your client. The donor is subject to Section 4 of the Mental Capacity Act. They are making the decisions subject to the best interest principle for their person, the donor who appointed them. So it is the donor who remains your client, not the attorney. However, on a practical basis, it is the attorney. If someone's lost capacity completely and you're dealing just with the attorney, it is the attorney you'll be dealing with. I think we should have a little bit of sympathy here for some attorneys, particularly in the kind of later life decisions you might be dealing with. We're going to be looking at estate planning and things, for example. If someone's agreed to be somebody's attorney, they may have done that with the best will in the world, and suddenly they find themselves having to make decisions which actually they're possibly not really well prepared for. So one of the ways that you can help in a later life capacity of dealing with older people is where you are dealing with attorneys, where on your client files you know that someone is an attorney, perhaps you could consider giving extra support for attorneys. So that might be a good way to, show the benefit. So I think we all have to know that you do have to show the value of advice. If someone is an attorney, it might be good to try and find out how much financial acumen they actually have and how much they might need. So even producing articles, notes, little guidance for attorneys on financial decisions might help them to do that role better, because some of them are thrust into a role that they're well-meaning but they're not prepared to do. Going on to item 3, any decision made by the attorney could not have been made by the donor. It is the one the donor would want to make. Interesting point. As we said earlier on, the best interest principle, the principles that guide the Mental Capacity Act in relation to substituted decision making is that in every circumstance, the attorney should determine whether or not the donor can make this decision. Now, I know it's where people have completely lost capacity with advanced dementia. That is clear cut, so we'll take that as read. But there are lots of circumstances where there's fluctuating capacity, and that goes back to our point earlier about trying to facilitate meetings at a time that would mean you've got the best opportunity for the person to participate. So the attorney would have to say that the person couldn't make that decision, that with all the help and support you gave them, they're not able to make the decision and not even able to participate in that one. But under Section 4 of the best interest principle, that's for the attorney to decide before they act. And I think, as I say, in terms of best practice, that you should note that. But it is the one the donor would want to make. This is a really, those few words cover quite a complex issue. So let me just give some key, if I may, some key thoughts about that. Under the best interest principle is not defined, as you know. There's not a definition that says what is best interest. There's a practice guidance that gives you it gives you examples of what best practice, best interest would look like. So there are some things, which is what is it one the donor would want to make? How would you know that if the donor's lost capacity? Well, one of the things that the attorney would be required to look at would be to gauge the indications of what a person has done in the past. Now that would be evidential towards saying that that was the kind of thing they wanted to do in the future. Another thing that's important to do, and this is for the attorney to do, so I'll come on to how I think you interact with that in a moment, but one other way would be to see, is there any evidence of the donor when they had capacity having expressed their wishes or views? Now the best one you could possibly get would be if the donor had happened to write it all down. I think the likelihood of donors having written it all down is quite slight, but you could look at the kind of decisions they've made, the kind of policies they had, things that have been important to them. And the more it's written, the better it is. But it's equally evidential and quite important to say, well, let's ask people that have an involvement with that donor at that time to see if we can express their views. So that's the attorney's role. But I think in terms of best practice, somewhere in where you're evidencing your case notes, you should give reference to the fact that you've actually spoken to the attorney and made that point. So you've said to them, obviously, when you're looking at this, how did you arrive at that decision? I mean, I'm abbreviating this for the sake of time, so I'm not suggesting this they'd be quite that direct, but I do know that financial advisors are really skilled at, communication, because that's what you do. But it's important that you do that. So, for example, if the attorney came along and wanted to only make green investments, they only want to invest in green investments because they feel very strongly about that. Did the donor feel strongly about that? Because clearly that might well limit the investment strategy they have. So that's just a simple example. Is there more than one attorney? Always important. One of the things that we always ask people is, financial advisors and the work we do with them, what do you do if you get a power of attorney? Everyone will, I hope, will always say that they do record that they have it, that they photocopy it, they annex it in their file. Not everybody says read it. Now, I'm assuming that's because it's so obvious. But just in case it isn't, that is the key point. If you look at Articles 4 and 5, and the power of attorney is not just a power of attorney. There is a standard template, but it does allow for a lot of differing into points in there. So you can have more than one attorney. Are they acting jointly? Do they have to act jointly and severally? So check first of all, and then importantly, there can be limits on the power an attorney holds. So is this person able to make this decision in front of you? I.e., if it's jointly, the other person should be there. If it's jointly and severally, yes, they can. So are they able to make that decision? Followed by, is this a decision that they are able to make, or does the power of attorney limit what they can do? So you need to satisfy yourself and note that you've recorded that. Now, the other bit, which is a topic on safeguarding that we, during the course of the year, will pick up, is a whole topic around what to do if you're not satisfied with the attorney's actions. Here again, going back to the FCA, they've given some interesting observations on that, in which they say that in terms of vulnerability, an advisor, in order to show that they are treating the area of vulnerability seriously and giving credence to it, should also be aware of what to do if they are unhappy with what the attorney is doing. So there are strategies that can be used, and certainly everybody should know that local authorities all have an adult safeguarding person that you can contact, that the OPG has facilities to contact. They have telephones that you can call. So it's really important to just make a note for yourself within the firm what those contact numbers are and what you would do. And as I say, on another subject later this year, we'll address in more detail the issue of safeguarding. But today's topic is wider than that. I just want to end on my section on new advice on making gifts. If you haven't got this, please can I ask you all to get it? We'll send you the link to it, and it came out on the 18th of January. And it's new guidance, and it consolidates the old guidance, obviously. What it does, though, which is helpful, is it makes reference to some up-to-date cases. So it goes through some of the key things that are really principles on making gifts. It goes through capacity to making gifts, and it walks you through some of the cases and the thought process behind how the court arrived at that decision in a consolidated form, obviously. Not everybody wants to read 100 pages of legal judgment. There's some important points in it, though. I just want to highlight these. The bit we've mentioned earlier, which is about involving the person in the decision, which I think we've covered in detail today. Some bits that arise quite often is, can the attorney receive a gift themselves? Now, the OP, that is covered in this guidance. If I said yes, that would be a brief example. Please do look at this. It looks at the concept of reasonable gifts. Can you make gifts out of estate? One of the things I would say you should all look at is, because we're going to look at, this is partly about estate planning. Frequently what comes up is things like gifts that would be gifts out of income, for example, or using up the allowance for that year. Can you do those without asking the court? How much can we fit regular inter-virus gifting into an estate planning strategy without having, on the basis that you can do it using a power of attorney? There is a principle in there called the de minimis principle, which is, I would ask you all, time constraints stable, I would ask you all in the guidance to look at, which is about the circumstances where you can do that, where provided, I'd say a minimum point is the estate has to be over the IHT exemption. So you have to show that it is an IHT strategy. It's got to be over 325. And then the court are looking at using those allowances in relation to the overall value of the estate. What would that mean in terms of taking money from the estate? The impact that would have on the person's lifestyle. And that includes actually looking at their future lifestyle. So here again, one of the things that's quite important to look at is to be able to show that you have taken into account that, and that's where financial services can be very helpful as well as working with solicitors, because you're very used to mapping and modelling financial outcomes. And for these gifts to be made and show that they would meet the de minimis rule, anyone making that an attorney would have to be able to show that they had modelled the impact this would have on a donor's lifestyle. So I think that's a real key area for you to look at with that, as is the issue around what is, it comes down what is a reasonable gift. And it also covers, as well, I think, quite important, gifts of property. So I think if you haven't, and there's one other point I would just add on this before I finish. One key way to look at gifting is to look at, if you can, the will of the person, because the will is an expression of what they would really want to happen to their money. So this new guidance is really valuable. As I say, it came out on the 18th. If you haven't got it, there is a link to it. Do get it. And it leads, importantly, on to issues around estate planning. So I'm going to hand over to Nick to continue that.
Okay.
Thank you very much, Tish. I will say, if you have got any further questions for Tish, please keep bringing them in to us. If we can't answer them today, we'll certainly look to pick them up at a later date. I think actually what I felt through there is that almost that when it comes to estate planning, it's almost a reminder here that this is about a family situation. So I think often we think about inheritance tax affecting one person. I think that's particularly true when I deal with advisors and think, let's talk about estate planning. They immediately think about their 70-year-old clients, think, well, actually, no, it's much broader than that. If you're dealing with a 50-year-old client, they're part of the family, and actually, in some ways, it shows them the wider opportunity to get involved in estate planning. So if you think, well, most of my clients are 50 years old, you have a huge number of beneficiaries there that are ultimately affected by estate planning. We've done some research looking at estate planning. I think there's quite a neat figure that comes out here about a large chunk, 57% of advisor clients would benefit from doing some sort of IHT planning. I guess I sort of look at that and go, oh, it's a good figure. It seems that it's an area that people want to get involved in. I guess almost the thinking point there is, oh, why do many of them, why have they not done it yet? And I think that perhaps again comes back to some things Tish was talking about there, very much the sort of the emotional over the mathematical. You know, we think about sometimes in financial services, passing our exams and so on and sort of working out how someone doesn't pay inheritance tax. But underneath it is a much more complex situation around, again, a family situation. I know certainly when I talk to advisors about this, you know, why your client's not doing something about it. Sometimes it might be, well, they don't want to think about it. It's an awkward thing to think about your own mortality or that of your parents. You might get these statements saying, "Oh, my kids will get enough." You know, I never got anything before. I feel that the advisors that are successful in it go back to some of the early things that Tish was saying about just give clarity. So on this slide, it talks about residential nil rate band and all these sort of very difficult things that are complex enough for advisors to understand. So for clients to understand, even more difficult. Advisors that I feel that are successful in this space will make it very clear. These are your allowances. This is how much money you've got. And just make it clear by doing nothing about this, what does it actually mean? I think by telling them there's a 40% tax above a double nil rate band, that now includes a residential nil rate band, it's just fallen on deaf ears in terms of, as you say, how anyone's brain actually takes that in. If you say to them, this is the money you have, this is the allowances you have, I'll take a simple example. Let's say you're £500,000 above the allowances. So I was just highlighting to you that £200,000 will go to the revenue on your death rather than your children or grandchildren. Now, does that bother you? And I think that's always a good opening question. And if that doesn't bother you, then perhaps you understand more about the family dynamics. But if it does bother you, then perhaps we need to do some planning around this. Yeah, a point made there is that have you made a will? That should be your very first port of call. Should you update it and so on? But there's lots of planning reasons why you want to get involved. I guess the issue I see sort of time and time again is that once you've gone through that, do I want to do something about it? It's not that simple there, because estate planning means lots of things. We have a number of guides that work well with this. There's a great guide we produced called Untangling Inheritance Tax, another one I'd urge you to come and get from us. And it talks about the breadth of planning you can put in place, how you gift, how you do whole of life, how you use trust, and so on and so forth. I guess the constant that we'll see is that, yes, that 500,000 on that example might be above the nil rate band. So one way I could solve this is to give that money away, either a straight check or I could put it under trust. But I might not want to do that because I might need that money. So back to sort of what keeps people awake at night, how do I look after myself first and foremost? I think for many people, estate planning is a secondary concern. Yes, I don't want my children to suffer this tax bill, but I don't necessarily want to give the money away. I might need it, and they might. I'm sure you've done lots of research at SOLLA about care costs and how much that might be. The end of your life could be the most expensive part of your life. £50,000 a year care cost is fairly typical, I guess, and depending on where you are.
In London and South East.
Yeah, so that's, on my example, that's 10 years of care cost. This is a couple that actually doesn't sound like that much money in some ways. So I think that can often stop people. And I feel that this is very much where we come in. This is where we help. And this is where business property relief as a relief to utilize can help tick some of the boxes. I find when I meet clients that are always alongside financial advisors, I'm always very keen to make sure they actually understand clearly what they're going to, the risks and benefits, like you would with any underlying investment. But I always find the starting point is business property relief. If I'm sitting in front of an 80-year-old client and saying, right, the way we're going to solve your estate planning needs is using something called business property relief, you know, that will seem very foreign to them because then, well, I'm not running a business, I don't have any property, why do I get the relief? And perhaps people are nervous about tax planning sometimes. They feel it's not allowed, or that it's going to be the next headline on a newspaper somewhere. The guide actually that we brought out has a very good part, you know, page 18, which is in front of me here, that I think is a good way of actually explaining why is this relief here, how do you claim it, how does it work, and so on. A form I carry with me in my folder all the time is the revenue form, the IHT 400. Again, we've made note of that within the guide. The IHT 400 is not a nice form. It's one that gets completed by on someone's death, talks about who died, talks about their will, and ultimately talks about the assets that they have. And in there, very usefully, section 39 talks about business property relief qualifying assets. It helps clients understand that they're not avoiding a tax, they're claiming a relief. There's a very important distinction between those two areas. It helps, I guess, why is there relief there? Well, the government is often providing you with relief that they've given you throughout your lifetime. Here, it's encouraging you to invest into companies you wouldn't ordinarily invest into because they all carry additional risk in those investments, with the goal broadly to help the UK economy. So they need to understand that they're investing in things that are different. The relief itself has been around for a long time. So 1976 is when it came in, so over 40 years old. So you haven't just found this little bit of legislation that you're looking at here. You're working with it clearly. In terms of how it works, again, simplicity, I think, holds the goal here. Back to my issue in the previous example, I don't want to give the money away, but I want my children to benefit from all my wealth on my death. In the same way I write my will, this is just an investment. It's not a gift. It's not under trust. There's no underwriting. There's no sort of complexity around that. You must hold the investment on your death, and you must hold it for at least 2 years. That's also useful using that IHT 400 form, really sort of shows that it's an on-death allowance. So very simple, and I think you can't downplay the importance of simplicity around planning for these clients. The fact you have access and control, I think, is a hugely important point. The speed, the 2-year point, can be relevant to clients in much later life, or perhaps those with illnesses. But I feel that the more people I've met to deal with business property relief, it's the access and the control that's perhaps the biggest driver for them, more so than the 2-year planning. In terms of what you're going into, there are different styles of investments you can go into to qualify for business property relief. I'm not talking about just the Octopus Investments here. There's a range of types of investments that will qualify. And like all investments, they'll have a range of different style of returns, both in terms of potential return, potential volatility. And I think you want to understand those and the relative merits of those different investments. In terms of the benefits, make those clear. Clearly, a huge benefit is down to the underlying investments are exempt from inheritance tax. And that's a significant advantage. You've made investments to your clients all the way along to make sure you capture growth, be that by choosing good investments, but you can't just choose good investments that aren't in good tax environments. Otherwise, you're not achieving the underlying client's goal. Risks are clearly important, that they understand that's additional risk they're taking, and putting that in context again to their goal. I think a common thing that comes up is saying, well, how would an 80-year-old have an investment that would, say, for example, be in AIM stocks? That just wouldn't be an appropriate investment. And in isolation, it wouldn't meet their risk profile. But risk is not just about risk profile, it's about goal. So if I come to an advisor saying that, yeah, I'll give a big figure here to keep it simple. I want to give my children £1 million when I die. Now, as an advisor, you say, well, if I do nothing with this money, then I won't achieve your goal because it will be worth 600,000 if we just leave it not growing at all. I can achieve your goal if I grow your money quite aggressively. I need to get your money from £1 million to 1.67 million, and on death, it'll be taxed at 40%, and then that will leave your children £1 million, and I have achieved your goal. But for me, that brings the risk in a much better context, the risk I'd have to take to get the additional performance. Or I can invest into areas that don't attract that very punitive tax, which is going to mean that perhaps I don't need to get so much growth to meet your underlying goal. So it's seeing in context, and it's seeing, I guess, the planning that we offer, again, very much in context. It's a proportion of overall planning. Sometimes it's a large part, depending on client circumstances. Sometimes it's a relatively small part. But your portfolio planners in all of your lifetime, and I think this is a portfolio planning example here as well. In terms of how we help, I think there's a really sort of key part from this here. Yeah, I cover the London region, but around the country, there's a very strong team that can come in and speak to you about individual clients. We run a lot of events. There's plenty of webinars that we run, including today. Hopefully you find our product literature clear and usable, and we very much sort of have a sort of granny and granddad test to our material to make it clear and readable. Lots of reports, lots of due diligence. We work with STIFA as well. So there's a huge amount that we're providing here. And hopefully what comes across there is that it's very easy for us just to be a product provider. I can see an IFA and said that here is our brochure, this is the product. I see our role as much, much wider than that. We are a product partner. We want to help you find opportunities, work closely with you with clients. We want to have an in-depth understanding of exactly how we can help. And I think it's a really key part of what we do at Octopus. So if you haven't engaged with us before, hopefully you will now, and we'd really appreciate your contact and how we can help you.
Great, thanks so much, both to Nick and Tish. I think that was really, really insightful, so thank you so much for your time. I'm conscious that I don't want us to overrun too much. There are a few questions which I think we'll do a couple now, and the rest we will pick up after this webinar. So just as a common question that's been coming through, how do I get a copy of this guide, which talks about a lot of these sorts of things, which is a Octopus and SOLLA guide. So there'll be a follow-up email that will go out to you after this webinar, and you can request a copy through that. Alternatively, it is on our website, so it's octopusinvestments.com/estate planning hub, and you can either request an online or a soft copy, or indeed a hard copy if you wish. So Tish, one question that we had, which you did highlight on, but I think it's probably quite important to reiterate because it's come up a few times. When you meet a new client and there is a power of attorney, what best practice would you recommend in this case? So you talked about obviously reading the power of attorney and making sure that it's understood in terms of how it is, but what other things would you recommend?
Right, I think that's a really good point. When you're meeting for the first time, I'm starting from the basis there that you don't know the attorney either, so it's an entirely new client that's come along. Yes, it's really important to get the power of attorney and to read it and to note, as we've said before, whether or not they can make decisions, and if so, what kind of decisions can they make. But I think it's also important to get as much as you can in terms of background information around the family and around the dynamics of that family, and that can be achieved just by way of a general conversation. So the client is just having a conversation with you, but you're steering that conversation to get some key points. So I'd say, as I said, around the family structure, are there people other than the attorney who are family members, who the person lives with, who they have interaction with. Those things are really important to give you a feel for that. For the new client as well, a little bit about to try and understand what their financial background is, because I did say earlier that there may be, as people get older, less fluid ability and therefore a bias towards reaffirming decisions they've made in the past. So in order to be aware that is a bias, it's quite helpful to have had a background about what kind of financial matters they've dealt with before. Equally, I do think it's quite useful to get a feel for that from the attorneys themselves, because it's undeniably the case, and it's one of the things that I think the FCA perhaps do recognise increasingly is a challenge, is that you heard Nick speaking about risk earlier on and about evaluating risk. And goodness knows all you advisors have read an enormous amount about attitudes to risk, ability to absorb risk, etc. But I also said to you that the donor was your client. The tricky bit with substituted decision making is that the donor is your client and a lot is written around attitude to risk, appetite to risk, etc. But the person that's making the risk decision is actually the attorney. So it's their attitude to risk, their views around risk taking that will, if you like, inform the decision that they make. They will have to justify that in terms of best interest, clearly, but it is therefore important to get a feel for what the attorney themselves has in terms of a profile. So I would say, just to consider that family history, relationships, past relationships with financial services and dealings with them, kind of things they've done. What things are of interest to them? You heard about estate planning today. I'll just throw this in. So, it's obviously a much wider topic than this. But if people are looking at making inter-virus gifts for estate planning and the attorney is generating that conversation, one of the things important is, has that person actually expressed an interest in estate planning before, the donor themselves? Because as Nick said, some people it may not be an issue to them. So if the attorney places a disproportionate interest in estate planning, that may actually not necessarily be prima facie in the donor's best interest. Whereas if you can see a pattern in the background of them taking notice of the tax implications of capital taxes, capital gains tax, inheritance tax, that would be very useful information in looking at things like estate planning.
Do you think capacity for loss also comes into that in terms of risk profiling?
I think capacity for loss, yes, and I should say that, but that's really important as well. But going back to that, that may well be the attorney making that decision, because actually the loss would be the donors. And I do think there's one thing which Nick said, and which I think maybe I should have reinforced there, which is all the current research does show as well that older people do prioritise current matters over future matters. So they are more likely to look at what they should do now, as opposed, they discount the future matters. And one of the things it said all the time, people they underestimate how long they're going to live. And, you know, that appetite, that ability to deal with loss, you know, if you're going to give assets away, you've really got to have shown that you've looked at almost like the worst case scenario. Nick mentioned it. If this person were to go into care, could they stress test that? Could they cope with that? Because that loss would be a catastrophic loss. So I think that is quite important. It's quite hard to get that conversation around, because, you know, people discount what will happen in the future and they underestimate how long they're going to live.
Great, thanks for that, Tish. And we'll do one final question before we finish up for today. So something that you mentioned actually that's really important is documenting meetings with older clients. I thought it might be useful to go into that in a bit more detail and what you think is best practice and what the best way is to do that, practically speaking.
Okay, yeah, I think, well, one of the things I'd say is definitely come on some of our SOLLA training, because we do cover that in some detail, because it's really important. I think the thing to do is to look at what you're trying to achieve. So documenting things just for the sake of documenting is just one more lot of paperwork you don't need. So what are you trying to achieve? You're trying to achieve two things. One, you're trying to achieve, importantly, knowing the important point about knowing your client, knowing the background enough, as I've mentioned in answering the last question. And the other is, and there's nothing wrong with that, it's be covering yourself in terms of compliance and best practice. So going back to that, if you think back to what I said earlier, there may be situations where you're not being asked to make a value judgment, but it is really important that you document that you know these things are relevant. So going back to that, I would say some practices that we know in SOLLA that do a lot of work with older people, they develop their own templates. And in SOLLA, we're happy to help look at that with you, which is a kind of standard template that makes sure that you don't forget to include all those key bits. And they are the ones I've mentioned before, about the family, about the power of attorney, about wills, about the past relationships with financial services. Who was there at the time that these discussions took place? Was the person seen alone is key, and have standard lines that you use about why you're putting that in, so it's clear that you understood why you were doing that. If they didn't want to be seen alone, why? You don't have to say whether or not you think Mrs. Smith's son was sitting overly close to her or answering her questions for her, but you could make a general observation about whether or not she was more proactive than this person was. You're trying to cover a situation where someone goes back and says, tell me what happened, that you could show that the person understood what the decisions they're making, or the person that made them understood, that you knew your client well enough to be able to guide and help them with that, that there was no issues, or that you minimised the opportunity for there to be undue influence, or that if you thought there might be undue influence, that you noted that, and importantly, that you acted upon it.
Do you have much feedback from the underlying clients in terms of some of the size of reports that they're actually receiving? I was at a client meeting just this week, and they were swamped by paperwork, and there's a 100-page report in front of them there. Do you think that makes people disengage with the planning a little bit there?
I think it probably does. I think you're caught between a rock and a hard place in the things you have to do.
Yeah.
That's why I would say that perhaps you should look at additional things. So you have covered that, but you've also covered some key points which come out in chunks that you think would help them to make that decision. Clearly written, larger font, and that's not patronising, that's just a matter of fact. Clear paragraphs, very dense text. It's hard for older people to take on in terms of complex information. There again, a lot of our SOLLA members do this, and we always encourage it. There isn't any reason why you can't get one of your just healthy brains, but maybe an aging member of your family or friend, to stress test some of the documentation that you use. So if you've got a standard template, You can make it Mrs. Smith and Mr. X rather than a person, but you know that the flow of it, the sequential way in which you provide information, and ask them to look at it and say, if you had this, and I was trying to explain to you about, for example, care funding, would you be able to understand it? Because actually, sometimes another person looking at things is really important. It happens all the time in law as well. If you know a topic, you are predisposed to think that it's intelligible, and it's quite difficult sometimes to see the wood for the trees. So yes, I'm afraid we can't get around some of the dense amounts of things you have to do, but you could provide additional information. And also, can I just say, some kind of feedback is helpful too. Because remember that communication is not a passive activity. So one of the things that's important is to be able to satisfy yourself that Mrs. Smith understood what you said to them. And that can be a technique. We use it a lot. When we do our accreditation, we test people's soft skills, and one of the tests would be around, how would you identify that Mrs. Smith understood what you were saying? And document that. Perhaps even document some of the questions that you asked.
That's really useful. Thanks for that, Tish. So I'd like to thank both Nick and Tish for joining us today. Thank you all for listening to us. If you have any further questions following this webinar, please don't hesitate to get in contact with us. We've got a lot of questions here, so we will look to put something together after this webinar, which will be with you hopefully in the next few weeks. But yeah, any feedback or anything, please let us know. And yeah, thank you all for listening.
Thank you.
Thank you.